Call to order the Special Committee on the Family Division of the Circuit Court for May 2nd, 2023. Some opening remarks from me. I've been encouraged by senior leadership to give these remarks and in a smaller version at the beginning of each of our meetings. For the record, I am Representative Mark Pearson, Chairman of the Special Committee on the Family Division of the Circuit Court. It is Tuesday morning, May 2nd, 2023. God willing, we will be meeting on May 9th, 16th, and 23rd at 9:30. We will be taking the day after Memorial Day off. We may meet one or more of the first 3 Tuesdays in June. We are investigating the possibility of a field trip to spend a morning in attendance at family court somewhere in New Hampshire. On several of the days this spring, we will be hearing presentations from various of the stakeholder groups mentioned in the memorandum of April 10th, 2023, from the Speaker's office establishing this special committee. Today, we will be hearing from the DCYF and from the Guardians ad Litem. Next week, we hope to hear from the New Hampshire Legal Assistants, particularly from their Domestic Violence Advocacy Project Director, and from the New Hampshire Bar Association Family Law Section and the Bar Association Pro Bono Governing Board. We hope to schedule presentations from Child Support Services and individuals from OPLC, the Office of Professional Licensure and Certification. As needed, and as at the call of the chair, we will be asking for specific information in person from the judicial branch. I want to spend a little bit of time talking about a committee that operated 11 years ago and tell you at the end the reasons I just told you what I did. There are 2 documents I wish to cite, documents that are part of the public record that you may access if you wish. First, the House Journal of March 21, the year 2012. It contains reports from the Committee for the Redress of Grievances. Each report summarized individual petitions with findings of either grievance founded, grievance founded with recommendations, or grievance unfounded. The second document, also in the public record, is a special report to the Speaker of the House of Representatives, the Honorable William L. O'Brien, dated November 19, 2012, by Representative Paul Ingbretson, Chair. It provides an extensive overview of how the committee conducted its business, the procedures required of those submitting petitions to the committee. We have those as well. Forms the committee used in making reports, we will be developing those as needed, and interpretive rulings, that is to say, guidance from the Legislative Ethics Committee. I mention these 2 documents because many people today allude to that 2012 committee with various degrees of understanding as to what it actually was and what it actually did. There were 28 petitions initially submitted, with 1 withdrawn by the petitioner. To quote from the November 19th committee report, the majority of the petitions claimed violations of due process relating to the judicial branch family division, as well as guardians ad litem in divorce cases. Other petitions involved alleged abuses of parental rights, the best interests of the child, and other abuses of discretion or power by decision makers. This is a quote. The petitions sought relief against judges, marital masters, guardians ad litem, and agency staff disproportionately from the Department of Health and Human Services. From the Concord Monitor article, last modified September 29, 2012, comes this statement. The committee determined 20 of the 27 complaints were legitimate and pronounced 7 unfounded. If you read through the various documents coming from this process 11 years ago, you will discover that reviews were done of court cases in great detail. While the committee had no authority to overturn court decisions because of the New Hampshire Supreme Court ruling of Merrill v. Sherburne, 1818, Nevertheless, the committee made recommendations against certain judges and marital masters being mentioned by name, and it made specific recommendations for legislation. First, I mention all of this to steer people invoking the memory of this committee for the redress of grievances to inform themselves of what it actually was and did before quoting it. And secondly, to let anyone coming before us to know in no uncertain terms, we are not round two of that committee. We will not be reviewing court cases, but looking only at slices, little sections of a case. Nor will we be making specific recommendations about any individual. Those of you wishing to testify, please fill out a pink card. While you have only to write your name, I suggest, but do not require, that you also put on the card your telephone number and email address written very legibly, so that later, as the committee starts looking at specific categories of alleged difficulties in the family court system, should we need more information from you, we can find you. It has been strongly suggested to me that I read the notice and disclaimer statement before every committee hearing. Those of you who get the House record will recall that last week this notice was on the back page. I believe it will continue to appear. But anyway, I'm asked to read this, so here goes. The Special Committee on Family Division of the Circuit Court was formed to investigate allegations of irregularities, including failure to follow or enforce statutes, unwarranted waiver of or failure to follow court rules, delay in rendering decisions, denial of due process, and other procedural issues. The committee will conduct hearings relative to the process of the Family Division of Circuit Court and may make recommendations for future legislation. The purpose of the committee is to discover areas where changes in procedure or changes in law regarding the Family Division of the Circuit Court might be made. The purpose of this special committee is not to retry the cases of citizens who disagree with the outcome of litigation. That is not what we're here for. If you wish to appeal, there's an appellate court you go to, not here. Members of the public will be given the opportunity to testify and present information to the committee. Because of the number of people who may wish to testify, there may be a time limit imposed on each person testifying, which is permissible under House Rule 100. Appropriate subject matter for testifying will be limited to specific instances of where there seem to be irregularities in process, procedure, or adherence to rules and statutes. That's it. Appropriate subject matter. Those testifying about subject matter relating to a court case or who submit documentation relating to a court case should know that both will be made part of the public record. Therefore, subject matter that is either confidential or may be under seal should not be discussed, should not be submitted to the committee, as disclosure of such matters would be a violation of statute or a court order. The committee reserves the right not to accept written or oral testimony or materials which would, in its judgment, violate the foregoing. That's the end of the specific statement, and I'll close with a few more things from me. Now, with that in mind, 3 things, please, should you wish to testify here. Number 1, that statement I just read was a joint effort of myself, the Speaker's office, and the House Legal Counsel. It has passed legal muster. Secondly, of the things you may present to us orally, electronically, or in written form, we as a committee do not know what may be confidential or under the seal. How could we know? Therefore, it is entirely up to those bringing us testimony to filter out those items, lest you find yourself in difficulty. You, the one wishing to provide testimony, are solely responsible for not bringing these matters forward. Additionally, under this point, there may be some items, simple facts, or broader anecdotes that are not confidential or under the seal that you nevertheless may want to present quietly, but not as public testimony. Because, should they be brought forth in form and they are accepted into the record, they become part of the public record. If you don't want the public to have access to the record of that item, don't create the record. And please, don't do or say or write anything that may be hurtful or embarrassing to your children. Third, this is how your testimony shall be presented to us. First of all, give your name. Secondly, please, to the degree you can remember, the date, time, courtroom, and judge where the alleged error of the court took place. Remember, we're not trying a case. We're looking at a slice or a snapshot, and we need to be able to identify that. And then third, give us the alleged error. What are you complaining about? Be extremely brief. Say it in one phrase. I believe there was a violation of the rules of evidence, or the judge let the other party introduce motion after motion after motion. Tell us in a phrase what your complaint is. Describe briefly why you think this is a violation of court rules. And then 5, if you or your lawyer objected at that time, what was the judge's ruling? Why did the judge say what the judge said, and why did the judge do what the judge did? You will have 5 minutes, at which point your microphone will be shut off. If you wish to give us written or electronic testimony, it must be as brief as 5 minutes if somebody were to read it aloud. If you cannot do this in 5 minutes or less, you're not following the rules of what we want. Those 5 items I gave can be done in under 5 minutes. If your testimony does not follow, you may be cut off from speaking further. If written or electronic, your testimony will not be accepted by us, and when we go to consider things, it won't be considered. Now, remember the last sentence of that notice and disclaimer. The committee reserves the right not to accept written or oral testimony or materials which would, in its judgment, violate the foregoing. The reason for this is not to be mean. It's not to be insensitive to what you're bringing us, but to remind you, please, we are not the second round of the Committee of Redress of Grievances. We're going about our business in a very different way. So the manner in which the testimony comes to us must serve that purpose. It must be usable if we're going to get anything done. So testimony in a different form won't be useful to us, and therefore we won't accept it. We don't need it. So give us what we need so we can make the suggestions for change that we would like to. So some of that will be read again next week and the week after. And with that in mind, the chair now recognizes the good folks from DCYF to come on up and make a presentation to us, who they are, what they do, and suggestions. And remember, we're solving problems here. We're trying to be making helpful recommendations. So come on.
Either way.
Sure.
Hi, good morning, everybody. Joe Ripsum, Director, DCYF. I'm joined today by attorneys Margison and Baker. So if there's any questions or thoughts about, specifically what happens in the courtroom, they're much better prepared to talk about it than I am. I'm really kind of at that higher level.
Who is the third person, for the record?
I'm Deanna, legal director for DCYF.
Baker. And what was the first name we just spelled?
Deanna.
Deanna. Okay. 74-year-old ears. And your chief legal. I actually wrote that. Yeah. Thank you.
Legal director.
She's legal director for kind of the court side of DCYF Legal.
Thank you. You may
Great.
proceed.
Go ahead. All right. So again, I'm Joe Ripsum, Director, DCYF. Wonderful to see everybody this morning. Thank you, Chair, for the guidance. Just had a few things that I wanted to share. I wanted to kind of first do a very brief overview of what we do in the space related to this commission, and a little bit about how the court process works, and then some ideas for things that might be able to be thought about differently or better. So first off, really going to focus on the child protection side of the house, because I think that's where this is. DCYF, for those of you who are familiar, really focuses on both child protection and juvenile justice, but for today's purposes, going to focus on the child protection side of that. The way the child protection system works, very, very high level. Things start with a call to intake. That's our 24/7 hotline. Somebody picks up that phone, takes information about allegations of abuse or neglect. We get north of 20,000 calls to that hotline a year. At that hotline, what somebody has to do is go through what those allegations are and make a determination that if those allegations are true, would they be abuse or neglect as a matter of law? And if the answer to that question is yes, then it gets screened in for an assessment or an investigation. We do just north of 10,000 investigations per year, assessments, investigations per year. At that point, there's a couple different things that happen. One, they're assessing to see whether, in fact, abuse or neglect as a matter of law has occurred. And two, they do a risk assessment to understand kind of what a family's needs and risks are, to determine are there any types of supports or services that would be helpful to that family to prevent abuse or neglect from happening in the future. Only about 10% of investigations result in a substantiated finding of abuse or neglect per year, and less than about 1,000 per year child abuse and neglect cases go to court. That's not how many are necessarily open at any given time, but that's how many go to court in a given year, right? So you're starting from north of 20,000, and the ones that go to court are counted in the hundreds. So there's quite a filter that occurs through that process. The times that we go to court really fall into a couple buckets. The broad way to think about it, the broad way that I think about it, is whenever we're going to do something that would impinge upon a parent's rights, then we should be going to court, right? So specifically, if a child's going to be removed from their home and put into foster care or some other type of placement, then we need to go to court. And once you go to court, there's judge oversight, attorney oversight, CASA oversight, et cetera, through that process. Or if we're going to do something that's going to otherwise, impinge on a parent's rights, say that we're limiting the access of a parent to a child, or we're going to try to get a court to order services for that family to try to keep, that family together and safe. The work over the past few years has shifted quite a bit. Back in 2015, the work really did, casework where we're opening up a case with families really happened only through the court process. And that's because laws had been changed and funding had been changed in the years prior to reduce our ability to offer voluntary services to families. That's all been reinstated around 2017, 2018 in terms of resources and funding. So at this point, if you looked at the number of cases that we have open, that's after investigation we're opening up, you'd see a couple different shifts. You would see that the number of kids in out-of-home care have decreased over the past few years. You would also see the number of in-home cases have increased. And you would see kind of a new category that has grown and actually surpassed the number of other types of cases, which we call prevention cases or voluntary cases. And those are cases where we're working with a family either directly on a voluntary basis or through a contracted provider on a voluntary basis. So there have been major shifts in the past few years to try to shift our work away from always relying on court as the intervention towards just being able to help families out because families need help. And that's a big change from the way that we had to do business about 5 or 6 years ago, when really everything had to go through court if you wanted to provide a service to a family. So that's kind of big picture overview. From where I sit, I think the DCYF's work with the family court has been, positive. I think, there are processes in place if there's disagreements on individual cases, right? Motions for reconsideration and appeal processes. There is also something called the Children in Court Improvement Project, which has meetings once a month. It includes judges, court staff, DCYF staff, parent attorneys, children's attorneys, CASAs, judicial counsel, and they meet monthly to talk about kind of how the children in court process is working for DCYF related matters, and create trainings and protocols and hosts of other things, sometimes come up with recommendations for legislation that have been passed in the years since I've been here. So, from that level, I think that works quite well, and it works quite well because they get, key stakeholders from across different sides of these issues to talk through what's working, what's not working, and how to make sure the process is working well for everybody involved. So big picture, that's kind of, background on this. If I want to, I can take questions now, or I can jump into some of my thoughts about where we might be thinking about doing better in the future if folks would like.
I'd like to give the committee a chance to ask any questions of what we've heard thus far. Representative Long.
Thank you, Mr. Chairman. Thank you, Mr. Ripson. The appeals and reconsideration process, what percentage is that at? And would that percentage be of the 100 that go to court?
I don't know, Deanna or Beth, if either of you.
So if I understand your question, Representative Long, you're saying that the appeals and reconsideration process, that is only for court-involved cases.
Okay. Okay, and what percentage, follow up if I may,
Follow up.
what percentage is that?
I don't know. I would have to ask Deanna. We do not have data on that.
Oh, okay. Okay, thank you.
Probably not a majority, right?
No. So Deanna's behind it. Sorry.
That was quick. Wow.
What I would say is that, so my position is the legal director position that in 2017 was placed under the supervision of the Attorney General's office. And so I am responsible for the supervision of the entire DCYF legal team, which consists now of a lot more attorneys, thankfully, to do the work. And because we are so connected now with the Attorney General's office, we are regularly looking at cases that come down that we disagree with. And if we need to, we are having conversations about the best approach to deal with the case. And we are also now able to take cases to the New Hampshire Supreme Court. Previously, we were required to do a de novo appeal. And now we are taking cases up and we are getting decisions, and it's been great.
Would you say that with the new and improved and enlarged team on site and appeals, this filters down so that judges will say, oh, if this kind of thing is likely to be appealed, we won't do this kind of thing. So the number of appeals is decreasing, one would hope?
Well, so the appeal process that's in place now has not been in place for a really long time. So we're still
Too soon to
getting
tell.
there. I would say that anytime new judges come on the bench, we think to ourselves, ooh, I hope they've been trained really well in child protection, because there's so many nuances to the work that we do. And Director Ribson referred to those protocols. Those are really helpful in giving a roadmap, not just to judges, but to everybody that's involved in the child protection system.
So we would hope that the soon-to-be expanded amount of hours devoted to continuing education of judges that I'm going to request will really get them up to speed quickly, and the number of appeals would start to move down as the system starts flowing better?
Potentially, as new laws are enacted, there's going to be challenges to those laws. So it's not just DCYF that's able to appeal, it's parent attorneys, it's CASA. Every party to our child protection cases can take a case to the Supreme Court.
For cause? Or just because they
No,
lost?
they're mandatory appeals.
Oh.
So they're accepted by the Supreme Court.
So
And we've
even-
seen a lot of, actually an increase recently in appeals from permanency decisions, which
Okay.
is sort of at the end of, I'm sorry, I can't see all of you, which is sort of at the end of the 169C child protection proceeding. We have something called a permanency hearing, and that's the point where we ask the court to adopt a permanent plan for a child, which hopefully is reunification. If not, it would be adoption, guardianship, or APLA, which is another planned permanent living arrangement.
Just to nail it down, this is a mandatory appeal,
Correct. The Supreme Court is taking them.
not
Yeah.
appeal for violation of law or process,
Right.
just mandatory.
I just want to make sure folks are clear on the term mandatory there. It's mandatory in terms that the Supreme Court must hear it if it is brought. It's not mandatory in the sense that an appeal must be brought on every case.
Thank you. Representative Smith.
Question, you mean mandatory right to appeal,
Correct.
Okay.
which is a very different
Yes.
statement than mandatory appeal. Thank you.
Yes.
Any other questions from the committee? Representative Long.
Thank you, Mr. Chairman. You spoke briefly on the permanency hearings as one common. I was going to ask any particular appeals or reconsiderations that stand out to you, other than it sounds like permanency hearings are one of them. Is there something else?
We frequently see appeals from termination of parental rights cases.
PRs, yeah.
And now, because we no longer need to have a de novo appeal before the Superior Court, there are appeals of 169C adjudicatory and dispositional orders.
Great. Thank you.
Representative McMahon.
Thank you, Mr. Chairman. Mr. Ripson, you spoke of a children in court improvement project that's ongoing. And based on the description of the special committee on the Family Circuit Court, is there a redundancy between that existing committee and what we're now initiating at this point?
I don't know that I would call it a redundancy because I think this committee has a broader purview that really is focused specifically on the processes that happen within a child protection court case, and a lot of it really digs deeply into, you know, the protocols for how things could best operate within court, right? So you have, of course, you know, your laws and you have your court rules, and this is a group of people that come together to try to make sure that on case by case basis, you know, that not on case by case basis, but that on individual cases, the process is working well. So I think there's definitely some overlap, but I wouldn't call it a redundancy because I think your purview is broader.
One follow-up, Mr. Chairman?
Follow up.
Brief follow-up. In the description of this committee is to review issues, quote, including failure to follow or enforce statutes, and the work for the improvement project. Is there any reports or data you could provide this committee on findings in that regard?
Yeah, so I think most of what they release comes out in the form of kind of court protocols and how kind of the court process is supposed to work, and those are public and published. So I imagine we could provide those so that folks can see, you know, kind of the outcome of that work.
Okay, thank you, sir. Thank you, Mr. Chairman.
And the chair is yet again grateful that the committee researchers are already typing out what I haven't yet asked her, but she knows I'm going to, and that is, who are they on this? When do they meet? And get me the reports. Thank you. Representative Smith.
Thank you. If I could just follow up on my colleague's comment, isn't the crucial difference that this is a legislative committee, and in terms of separation of powers, there are opportunities and responsibilities that the legislative branch has that significantly differ from either the administrative executive branch and the judicial branch?
Yeah, indeed, that makes sense to me. I'd agree.
Representative Lanza.
Thank you for taking my question. How many caseworkers do you usually have, and how much is their caseload when they have families that they have to see?
Yeah, so we have at this point, I think, if I'm talking just frontline caseworkers, because we have folks that do other types of casework. So frontline, that's our assessment workers that do investigations, and family service workers who do, you know, these court types of cases that we're talking about. I think we have somewhere around 280 positions. I think we have currently about a 10% vacancy rate, which is, you know, better than it has been. And in the current climate, you know, compared to what we're seeing in other areas of state government, it's, you know, better than what we're seeing, which I think part of that, I think that has to do with a couple things. One, there was work done over the last couple of years to adjust the salaries of frontline staff to make them more competitive with other states and other types of jobs, which has helped bring people in, and a lot of work to try to reduce caseloads, which, you know, when I first got here were in the 60s and currently are in the high teens. Our goal for caseloads, though, is to get lower than we are today. So the goal for us for caseloads is that we want to get to 12 cases per assessment staff. That's the folks doing the investigatory work, and 10 cases per family service worker. Those are the folks that do the ongoing cases. Right now, our caseloads have been hovering more in the mid to upper teens, up to even 20 for assessment staff, and in the mid-teens around 15, 14 for family service staff. And there's a few things that have contributed to that over the past few years, particularly over this last year. we've actually seen increased volume over the past 12 months in terms of calls to the hotline, in terms of new assessments, and in terms of court cases over the prior couple years. So the volume of work has actually grown. Even though our workforce has grown, the volume of work has also grown at the same time. And while I don't have good data on exactly what the driving forces are behind that, the anecdotal things that I'm hearing from staff is that a lot of it has to do with kind of what I would call increased complexity or acuity of some of the families and cases that we're working with, particularly related to things like fentanyl. And that being a substance that's just simply deadly. Compared to some of the other substances that we've historically been working with.
Representative Gregg.
Thank you, Mr. Chairman, and thank you for being here and answering our questions today. I just wondered, and I know that the complexity of case to case is very, very different, but do you have kind of like an average how long these investigations, and I do know that there's going to be some outliers either way, but what your normal length of time for doing an investigation and kind of coming to either founded or not founded is?
Yeah, so our protocol is that they're supposed to be completed within 60 days. I think on average we see that they are completed within 60 days, but there are a number that end up taking longer than that for a number of reasons. It could be within a discrete office workforce issues that are getting in the way. It could be complexities with co-occurring law enforcement investigations, which when that occurs, we kind of step into the front seat for the purpose of child safety, but they're kind of in the front seat for the purpose of investigatory processes. So we kind of take a step back to let them do what they need to do from a criminal perspective, which means that, some of our investigatory processes kind of get paused. So there's a couple different reasons why things could take longer than that, but I think on average and by policy, 60 days is the time frame.
Follow up.
Thank you. So when it does take a little bit longer, is there some kind of communication, like, not giving specifics, obviously, because you can't open up a case when it's still but saying like, hey, this is just going to take a little bit longer, or are people just kind of in limbo until it gets done?
Yeah, there should, caseworkers should be having communications with the families that they're working with all along. There's requirements for contact on a monthly basis and everything like that. So there should be communication happening about all that. Yeah.
In the, I jotted it down quickly, as Children in Court Improvement Project. That may not be the correct title exactly.
Did I get that wrong, Deanna?
No, I may have
No,
written it
I-
wrong.
I may have gotten it wrong too.
Well, I'm not playing one-downsmanship with you, so stop it.
It's the New Hampshire Court Improvement Project.
New Hampshire Court Improvement Project. Okay.
And
Are-
the group of us that are on the committee are called the Model Court.
Model,
The Model Court.
model, M-O-D-E-L, not
Correct.
M-O-T-T-L-E.
Yes. Model.
Model
Yes.
Court. Okay. And you would be part of this
I
group.
am.
Okay.
I have been since about 2009, I think.
79. Wow.
No, not that long.
Any other questions for what we've heard so far? Seeing none, pick it up.
Okay, so few areas that I have for recommendations, and I don't know how many of these would really be a huge surprise to folks, but one of the pain points I currently hear is access to bench time and judge time, right, which comes down to oftentimes the number of judges that we have available to hear cases. I do know that child protection cases tend to get priority, so if we are having a hard time accessing, I imagine that other folks who have cases before the family court have oftentimes even more difficulty accessing. I think that often does come down to just simply, availability of judges and the number of judges.
Well,
Couple
we're
of-
working on that this budget.
We are, and I'm glad to see that. A couple other things that come up a lot that I think are worth the committee's thought for the long term is thinking about parental representation and better support for that. And I believe there's something in this budget process for that as well. But we often have a hard time having enough parent attorneys to represent parents in these matters. Part of that could come down to the funding, and I do believe, like I said, there's something in the budget this year. I haven't been following it closely to address that issue. But also in terms of access to training and resources and support for those family attorneys that do parental representation in these cases. In New Hampshire, because we're a smaller state, this has been established essentially in a way that individual attorneys out in the community get paid an hourly rate to do this work. Other jurisdictions set up kind of centralized offices where you have staff attorneys who do this work that specialize in it. I don't know, I can't answer the question as to whether our state is of the size to support that. I think that's really a question for other folks to weigh in on, for the courts, the judicial council, et cetera. But it is something to think about, I think, in terms of being able to make sure you have a pool of attorneys that are capable, well-educated, supported in doing this work.
Could
and I'll
you,
pause 'cause I think I see a
could you
question.
give me a guess as to how many dedicated family attorneys, I don't mean they're dedicated to their job, they're dedicated to the task of being a family attorney, versus how many GP lawyers are you having do family from time to time?
Oh, I don't know that. Do you have any sense of that, Deanna?
That's difficult. I think that there's always been sort of a core group of attorneys who have represented parents in our cases, and many of them will travel anywhere from Berlin to Nashua, which is a huge swath, and it's a huge responsibility for those parent attorneys to have to do that work. Numbers wise, if I had to guess, I would say maybe 30 around the state that regularly do it and will take appointments. And that's just a guess.
So I'm going to beat this point to death. Therefore, those who are not dedicated specialists to this, but do it sometimes because it needs to be done, are at a disadvantage that they are not doing it full time.
Well-
And so therefore there needs to be more training.
Well, I think training is always a good thing.
I agree.
And I think that of those 30, those are the people that I'm saying, like, we see regularly. So we work with them regularly. They know the protocols, they know the statutes, and they understand the work. There are certain times when, private attorneys will come into our cases and they have no idea what the general process is supposed to look like. And sometimes those cases can go sideways.
Yeah. Representative Smith.
Thank you. When you are talking about the need for more attorneys specializing, are you also proposing that these attorneys be compensated with public funds?
Yes, as long as, the way that it currently works, if the parents, qualify for support on that, then public funds do support that. So I think to the extent that, and that's an awful lot of our cases, fall into that bucket. So yeah, public funds would need to be available to support that work.
Thank you.
Representative Ball.
Thank you, Chairman Pearson. Excuse me. I'm just curious if this list of attorneys who specialize in this field, is that list provided to all the parents, or is it accessible to the parents to know who to go to for representation?
So the courts generally know, the court clerks will know who in the area is willing to take the work. If we, over the years, if I've encountered an attorney who I think would be good at doing our work, I would encourage them to sign up with, thank you. Sign up with the court clerk in their area that they're willing to take the work. But there's not a list that parents can call and cold call attorneys and ask them, although they could call any attorney in the state of New Hampshire if they wanted to.
Follow up, please.
Follow up.
Thank you. So in other words, we don't have a law or anything in place that entitles parents that once they become involved with DCYF, that entitles them to be provided with a list of recommended attorneys.
They don't get a list of recommended attorneys, but they get appointed an attorney immediately by the court. So they, at their first hearing, will have somebody there that is there for them to work them through the process.
Thank you.
Sure.
You may continue.
Great. Couple other things that I would just, again, put forward as ideas for future work in this space. You do see in other jurisdictions, parent attorneys having other types of supports than we are able to offer them here. And specifically what I'm talking about is access to a social worker who works directly with the parent attorney and the parents. And the reason why that's valuable is, right, oftentimes when DCYF is first involved with the family, there's going to be an awful lot of distrust between the agency and the parents, right? And we're in an adversarial process, a court process, as much as in these instances, it's interesting because our goals are often aligned. The goals of both parties are typically to try to help heal the family and reunify the family. But Nevertheless, it is an adversarial process, and it is a process for which, it shouldn't be a surprise that a parent who's involved in that would be distrustful of the agency at that time. So the purpose in other jurisdictions of having a social worker work alongside of a parent's attorney is to, one, give that parent somebody else to talk to who can help kind of direct that parent towards the right types of supports and services, and hope maybe that person would be somebody the parent's a little more ready and willing to work with than our own staff in those moments where those tensions are high. And moreover, to be able to have a closer relationship with that parent that they're representing. One of the challenges that you see is that, frankly, attorney time is expensive. And attorney time is infrequent, right? There's just not enough of it. And that was even true in the state that I last worked in New Jersey, where we actually did have a dedicated unit to this. Even there, it was hard for attorneys to spend the amount of time with parents to be able to develop that type of trusting relationship and deep understanding of what was happening there that would be most beneficial to help that parent move forward and ultimately be successful in reunification. So the idea of injecting a social worker into that process, somebody who's got, maybe a different skill set in terms of engagement with the parents, a different skill set in terms of connecting those parents to resources and working alongside the agency and connecting those parents to resources, and in general being able to kind of speed up hopefully the timeline to reunification by getting those parents the supports and services that they need. So
Did you have this in New Jersey, a dedicated social worker?
we
like
only
this?
had a handful. It was a pilot program at the time in New Jersey. There's other jurisdictions that use it more broadly, though.
Representative Smith.
Thank you, Mr. Chair. And who would employ these social workers?
And that's where I think it gets really complicated in New Hampshire with our current structure, right? Where you have basically individual attorneys out there doing this work that are being compensated on an hourly basis. So I think that's something that would have to be thought through, potentially with the Judicial Council. I don't think it would be appropriate for DCYF to be that entity because, we're in an adversarial court process. And if they're our attorney or our social workers, you're not going to solve that kind of distrust process that I'm talking about. So I think you'd have to look to some other entity, potentially Judicial Council or potentially, some grouping of parents' attorneys who'd be willing to come together to support that type of work.
Thank you.
You may continue.
Great. The last big thing that I did want to talk about was the idea of family treatment court, which is something that we've piloted here in Sullivan County. The courts actually led the charge on that with us and many other stakeholders at the table with federal grant dollars. And this is essentially for folks who are familiar to kind of the drug court model for adult criminal cases. This is kind of the analog to that for child protection cases. And what you see in these processes are folks coming together more frequently, very, very frequent court hearings, oftentimes every 2 weeks. Of course, to support something like that, you need a lot more judge time and attorney time and staff time. And that's really the drain on resources to put forward something like a family treatment court. But you see really good outcomes in terms of being able to get those families who are struggling with substance use, and that being their primary reason for not being able to have their children, to have them be engaged in services quickly, have them being kind of very regularly seen and, supported through the court process, and having all the stakeholders who are part of this process, that is, right, the Child Protection Agency, the CASAs, the attorneys for the children, attorneys for parents, all those folks kind of part of this process on a regular basis with kind of a judicial oversight moving that through. It also creates kind of a forum locally for folks to think through how does the treatment process work for parents who are involved in the child protection system, and some space for local advocacy around prioritizing access for parents in these cases, right? Because there's obviously scarcity of resources everywhere. And at least in my own view, of all the people who need resources and access to treatment services, folks who, have young children that they're responsible for are pretty high up on that list in my view.
How long has this been going in Sullivan County?
Sullivan County, I think the pilot started a couple years ago, but they actually just started it was like a year of planning, so they started taking cases about a year ago. There are currently some conversations happening about how to implement some of the best practices from that in other courts, but there's not the resources in place to actually duplicate a full-fledged family treatment court in other places.
Have they issued a preliminary report yet?
I don't know that there's anything in writing. I haven't seen anything in writing yet, but
They're still in the trying it out and sharing stage. Okay,
Correct.
that'll be fascinating to look at. Representative Smith.
Thank you. Do you have any idea about what percentage of the child protection cases have the problem centered around drug use?
So if you're asking that question from the perspective of what's coming into calls at intake, that number is actually smaller than people would think. But if you're asking that question from the perspective of what goes to court, it's the majority have a substance use involvement that go to court. So when I talked earlier about kind of what we're seeing is this increased kind of acuity or complexity, those cases almost always involve substances. And I think I don't have an exact number, but it is probably the majority of cases that go to court that have a substance use dynamic.
Thank you.
Anyone else? Representative Long.
Thank you, Mr. Chairman. With respect to whether there's a child in your system with parents and you're working on reunification, is there an opportunity if there's been a civil action or a criminal action against one of the parents? Do you get those reports and do you use those in your determination? Do you get the questions?
Yeah, I'll let Deanna speak to that. Yeah.
I believe I'm understanding your question. So if there's a criminal action or another civil action, like a marital proceeding or a guardianship proceeding, it depends a little bit. Criminal cases, we work jointly with law enforcement, so we often get access to those records. We can certainly reach out to the court on non-confidential matters to get access to the cases. There have been times where we are not allowed access to guardianship cases because they're confidential. And so we then need to file a motion to intervene in those cases. And typically the courts will let us get the information we need to keep kids safe.
And follow-up.
Follow-up.
Yeah, just to, so you are able to access, you just have to file.
Correct. Yeah. So the court has the court call center. And thankfully, the administrative office of the courts worked with me years ago to come up with a form that we can use that we can submit by email to the court, and somebody somewhere in the court system, I'm not sure exactly who, responds to us with the information that we need.
Thank you.
Seeing no further questions, thank you, Attorney Baker, Attorney Margison, and Jersey Joe. And if you think of some other things and want to come back in a month for a slice of time, just let me know. Be happy to have you. And now we're going to look at the guardian ad litem with former judge for the Representative Ned Gordon. Please come up, sir. Thank you for coming. And former senator, yeah. Thank you.
Good morning, everyone. Nice to see some familiar faces.
You used to park next to me. He got your spot. Yeah.
For the record, my name is Ned Gordon, and I am a member of the Guardian Ad Litem Board. I am a public member appointed by the governor to serve in that capacity, and have been for some time. And I guess if you'd like me to start with a statement, I'll do that. Okay. I'm familiar with Guardian Ad Litems in three different capacities. One is an attorney who practiced and did some family law, as a judge, in which I actually appointed Guardian Ad Litems in certain circumstances, and as a senator. As a senator, I actually sponsored the legislation that created the Guardian Ad Litem Board back in the 1990s. Prior to that, the Guardian Ad Litems were appointed by the court, and there was authorization by court rule to appoint a Guardian Ad Litems. Guardian Ad Litems isn't something that was created by New Hampshire or is unique to New Hampshire. Virtually every jurisdiction in the country uses Guardian Ad Litems. But in our particular case, up until the 1990s, they were controlled pretty exclusively by the court. And there were no real standards for Guardian Ad Litems that were established at the time. There were no rules or standards for guardian ad litems for their practice, and there was no system of discipline other than what judges might impose. And so there were numbers of complaints at the time with regard to guardian ad litems, and that's what precipitated legislation back in the 1990s to create a guardian ad litem board. The guardian, and to take that responsibility for supervision from guardian ad litems away from the courts and actually put it into administrative services. The guardian ad litem board fell under administrative services. And the guardian ad litem board put in place rules, established standards, provided training for guardian ad litems, and they basically professionalized guardian ad litems more so than they were previously. Prior to that, basically a judge could pick whoever they wanted as a guardian ad litem, and back in those days, picked primarily attorneys because that's who judges knew as attorneys. But under the guardian ad litem board, you don't necessarily have to be an attorney to be a guardian ad litem. And I have to say that many of the finest guardian ad litems I worked with weren't attorneys, because basically a guardian ad litem, in many cases, the best guardian ad litems are ones that have good common sense. And that's not something necessarily you can teach. So the guardian ad litems, the role that they play in the state, they play a really critical role in our state, as they do in other states. There are certain circumstances where guardian ad litems are mandated. So just as you've heard in the DCYF cases, abuse and neglect cases, there's mandatory appointment of guardian ad litems. We have CASA, who provides in a majority of the cases across the state, guardian ad litems and abuse neglect cases. If they're unable to supply a CASA guardian ad litem in an abuse neglect case, then the court will appoint a private guardian ad litem, one who will agree to serve in that capacity. We appoint guardian ad litems in termination of parental rights cases, mandatory appointment. In divorce cases, it is not mandatory appointment. And up until we had our financial crisis in 2008, we used to, the state used to pay for guardian ad litems in parenting cases, in divorce cases, and parenting cases. And it, and that was, and which was very helpful and needed in many cases. But in 2008, it was decided that the state could no longer afford to do that. I have to say, you know, from my own experience, having been a judge at the time, that probably we were appointing too many guardian ad litems at the time, because in cases maybe where it just wasn't necessary because it was convenient to do that and the state was paying for it. But now I can say that there are certainly many marital cases where a guardian ad litem is needed and one doesn't get appointed because there is no means of paying for it. So right now we're appointing guardian ad litems when you can, in marital cases where you can find a means of paying for the guardian ad litem, either usually one or both of the parties to pay for those guardians ad litem. Why do you need a guardian ad litem? You know, I can tell you these circumstances, having sat there on the bench where one spouse is there saying, I need to have primary residential responsibility for Johnny because my ex over here, he's got a new girlfriend, they do drugs, they're stoned every night, they're selling drugs, there's people in and out of the house every day, all the times of the day, all times of the night. We need to do something. And he's only, you know, they're only sending him to school half the time. And so I need to have primary residential responsibility. And then I say, well, geez, you know, what do you say? And the guy says, well, geez, she can't believe, she's just saying that because she's getting benefits for having him in the house that's not true at all. And let me tell you about their house. She's got a new boyfriend with a criminal record as long as your arm. He's beating her up every night. There's domestic violence in the house. And the teacher tells me that Johnny, when Johnny comes to school, he wears the same clothes every day. He's dirty. And so you're there sitting as a judge and you say, well, geez, who do I believe? What do I do? Well, it would be really nice to have a guardian ad litem, somebody who could go out, talk to the teachers, find out what's going on, talk to somebody in the community that understands, talk to both of the parents, talk to Johnny, and get a sense of what's going on to help me make a good decision for what's in Johnny's best interest. And that's what a guardian ad litem does, works in the child's best interest. Guardian ad litems are basically fact finders, but generally make recommendations with regard to what may be in a child's best interest. The court has made it clear that when a guardian ad litem makes a recommendation or makes findings of facts, those findings of facts are evidence, just like any other evidence you hear. And so when a judge hears from a guardian ad litem, they consider that to be evidence. It's not not given favorable treatment. You measure the credibility of a guardian ad litem like you would the parties themselves. You hear what they have to say. You take it into consideration, but again, it's just evidence. And I can tell you, historically, there have been times when guardian ad litems have made recommendations, and I certainly have found the other way because I didn't think that was the right thing to do.
Let me interrupt to say the breadth of latitude of judges in family court is one of the major issues before us. So thank you for addressing that, and that's helpful.
Yep. The guardian ad litems, in terms of the guardian ad litem board, we act on complaints that come in to the guardian ad litem board. One of the things I think has happened since we've had the guardian ad litem board is that we have a more professional group of people because basically they have to go through a training process. They understand that there are standards that they have to follow. And if they don't follow those standards, they're subject to discipline. And we do, when it's appropriate, impose discipline on guardian ad litems at different levels. I mean, the worst being the fact that they would no longer be able to serve in that capacity in those circumstances. We do not get involved, just like you're in circumstances where you don't want to be involved in the middle of cases. The guardian ad litem board cannot get involved in the middle of a case. So if you just don't like what the guardian ad litem is saying or doing, we're not going to get involved with that. The case has to be complete in order for the guardian ad litem board to get involved and to make a determination as to whether a guardian ad litem acted properly. The guardian ad litems, we have many across the state. We probably could use a lot more. We used to have a lot more back when it was when there were a lot more cases. Prior to 2008, when we had when the system allowed for appointment and the state was funding guardian ad litems, there was a lot more activity with guardian ad litems. Judges, in terms of discretion, if you're talking about discretion of judges, there are two circumstances, particularly in marital cases, where you have guardian ad litems. One is the parties. What you find is that people with attorneys, particularly experienced and capable attorneys, will pick their own guardian ad litems because they know who's good and who will do a great job for them, or what guardian ad litem skills fit their particular case. So in those circumstances, the guardian ad litem gets picked that way. In other cases where people don't have the experience, don't know the guardian ad litems, they rely on the court to pick the guardian ad litem. When a court judge picks a guardian ad litem, they're going to do their best to try to pick someone that would be appropriate for the circumstances. So if the case was a case where one parent wants to move out of state, and the question is, where's Johnny going to live? Is Johnny going to live in New Hampshire, or is Johnny going to move with mom to Connecticut? And, you know, what's in the child's best interest? Well, you're going to pick a guardian ad litem, and you'd want a guardian ad litem that would have the skill to make that type of determination. Whereas if you had, you know, you had a very contentious case with people fighting, and the issues, like I indicated earlier, with drugs on one side and domestic abuse on the other, you might want a guardian ad litem with skills to handle those types of cases. And you get to learn the skills of guardian. As a judge, you learn the skills of the guardian ad litems over time. Some are much more capable of dealing with certain types of cases than others. Some, as I said, you can't teach common sense. That's something that you pick up from the guardian ad litems. A lot of people qualify as guardian ad litems. Judges have a tendency to use some of the same guardian ad litems over and over and over again because they trust them, you know. And it's the same as appointing attorneys for cases, and because you know who's competent and you can trust them to do a good job. So you tend to appoint people over and over again. In terms of the biggest concern I have with regard to the guardian ad litem board right now is the proposed change. What happened with the guardian ad litem board, it was taken out of administrative services and put under OPLC. In the proposal in House Bill 2, there was a proposal to take away the 7-member board that's been working, I think, pretty efficiently, and make it a 3-member advisory board. This was, and that was taken out of House Bill 2, was not put it in the Senate, but I understand that it's an effort politically to get it into another bill in the Senate. And that concerns me because I think that will deteriorate the way in which we've managed guardian ad litems and the quality that we have. And basically, one of the 3 members would be an appointment from the court, which may put us back where we were to begin with. And I don't really want to see us go in that direction. And I think that's what I can offer today.
Is there a differentiation in the percentage of JILs that the court would wish to appoint if one or both parties are pro se versus if both parties have retained counsel?
No, there wouldn't be any difference. I think we'd look at the type of case and the issues in the case to make that determination. Now, I have to say that different guardian ad litems have different rates. And so, you know, high-end cases may hire a guardian ad litem who would charge more for their services at a different rate. But in terms of the court appointing guardian ad litems, it would not make a difference to the judge with regard to the type or quality of the guardian ad litem.
Do any GALs serve pro bono?
I'm not aware of that. It could be that they are, but I'm not aware of it personally.
Thank you. Representative Gregg.
Thank you, Mr. Chairman. I actually have two questions, so get ready. I'm going to do follow-up.
I just had two.
Oh, okay. All right. I didn't know if we were allowed that. Thank you so much for being here today and for taking our questions. I had a couple questions. The first one, now in other states, I know they have a different program, but kind of similar. It's called Parental Rights Evaluator, so PRE, which is pretty similar. One big difference, though, that I see now, do the gals, do they do any kind of testing, like personality testing when they do this, psychological testing, anything like that that gets submitted as evidence, like for both parents?
Do they do, if I understand your question, you're asking whether or not the guardian ad litem's suggest that there be that type of testing for parents?
I don't know what they're like in other states, parental rights evaluators, they usually have some kind of like a psychology degree, psychiatry degree, because that way they can evaluate not just what the parent is telling them, but what an actual like personality test would show if there are signs of, sociopath or anything like that. Do we have anything like that within the GAL system?
No, there's no, there's no requirement that the guardian ad litem's have those types of skills.
Okay.
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 They potentially could have those types of skills, but there's no requirement that they have those types of skills. And there are other states where they have, like your parental evaluators, there are other states with guardian ad litem's which have specific agencies for guardian ad litem's, as opposed to our system in this state where we typically, with the typical informality of New Hampshire, we have guardian ad litem's coming out of the population, but other states have a dedicated group of guardian ad litem's, usually attorneys, to serve as guardian ad litem's.
Sure. Okay, thank you for that. And then my second question, so I know that specifically when you're working in cases, whether it be social work, victim advocacy or whatever, when you see a mass amount of cases, eventually there's a part of you, it's almost impossible not to become jaded or not to say, oh, I think I know what's going on here because I've seen 100 cases. Is there ongoing education for the GAL so that to kind of help them work through that, to get rid of those biases and stuff?
Yep. First of all, there's ongoing educational requirements for the guardian ad litem's. Though that's a very interesting question, because the one thing is, and I liken this to judges, because judges, they put these black robes on us as judges, and I think to make us look smart and infallible, but judges are just as human as everybody else, and they screw up and make mistakes at times. And the same thing with guardian ad litem's, they're human. And so I think that they're subject to all the human predispositions and concerns that everybody else is. And so I think what happens is, if I'm a judge and I see a guardian ad litem that I think is predisposed in a particular way, then I'm not going to use that guardian ad litem. I might not use them in a case where I think that predisposition is going to have an effect at all. There are some guardian ad litem's I won't use it or wouldn't use at all, because I just don't think they have the skill or the ability to do it. They might qualify as a guardian ad litem, but they're not necessarily who I think could do the job right. And so long and the short is, do I think that guardian ad litem's can make mistakes? Do I think that they're subject to predispositions and prejudices like everybody else? Yeah, I think they are. And I think that part of what a good judge does and part of the court system does is sort that out to make sure that that doesn't influence a case.
Representative Smith.
Thank you. Thank you, Mr. Chairman. We're here looking at the family court. can you tell us what you see may or may not be helpful in terms of how the family court operates vis-a-vis the judges being trained about the services of GAL and how they should proceed in those cases involving GAL? And you know you don't have to answer.
Yeah. No,
The chairman directs the witness to answer.
Okay.
yeah. No,
Doesn't work that way.
you know, I'm not sure I can give a blanket answer to that really, but the I think, yeah,
That's fine, thank you.
yeah, I want to give that some thought before I just speak.
That's more than acceptable, thank you.
And for the times when you ponder this, what we are really looking at is suggestions and recommendations. We're not critiquing, criticizing, redoing. We're just saying, how do we make a good thing? We'll stipulate the good thing better.
Yep. I think I can answer the question now. So, long and the short is, I think that that guardian ad litem should only be appointed when they're needed. There are many cases where judges can make decisions without having to have a guardian ad litem, I think, based on the evidence. And when they are appointed, they should be appointed just to serve as a guardian ad litem. Because lots of times, I think judges have a tendency to want to utilize them to assist in parenting, where I think they should be fact finders, make a recommendation, but not to get involved in assisting with the parenting itself. And I think that really becomes problematic. And this is just a matter of opinion, so I'm not sure I'm speaking specifically from the board as a matter of opinion. And other people have heard me say this, but the very first thing you learn in law school, and you're as a 1L, and you take your legal process course, is judge's role. The court's role is to decide cases in controversy. And the operative word there is to decide cases, not necessarily to solve cases. And if you understand the courts, you know that, and particularly in contentious cases and in divorce cases, you're not going to solve cases. And I think judges tend to, when judges tend to want to solve cases instead of deciding cases, that's when things become problematic. And so, long and the short is, when you start using guardian ad litems to go beyond deciding cases, then I think you may end up with problems.
Representative Long.
Thank you, Mr. Chairman. Thank you for your testimony. This is great, good stuff. You mentioned that GALs get appointed when the financial needs are met. Other than parents paying, is there another method where the financial needs may be met? So there isn't. So it's parental pay. And if I could follow up.
Yeah. And that's an interesting issue, because that sometimes that gets to be problematic in that one parent will one parent will step up to pay, and the other parent doesn't really necessarily want a guardian ad litem, but one parent will step up to pay, and then the question is, do you appoint a guardian ad litem in those circumstances?
And I know that's, if I could follow up, I know that's, one of the issues that we're gonna be hearing from, suspecting that. Do you sense where a guardian ad litem could lean towards the parent that's paying? I mean, is there any way of judging whether or not that could be the case?
Don't, do I think there's any circumstances where that could happen? Sure. Do I think there's a circumstance where that could happen? I don't think so. And I think if you have a judge that's responsible at all, they're going to make sure that there's not that type of predisposition.
And one more follow-up.
One
if I
more.
may.
Yep.
With respect to both parents paying or one parent paying, what would you say is the greater financial need? Is it one parent or both parents paying?
That when you say financial need, what,
The percentage of
Yeah.
awarding the GAL.
I don't know the answer to that. I don't think.
Okay,
I couldn't tell you.
thank you.
I was a judge in Franklin, so we didn't have many people paying for GALs in Franklin.
Is there a case where it seems that one parent is greater of means and can pay, and the other parent is not and might qualify for public funds, so that the payment winds up balancing out, but the direction is different?
No public funds.
No public funds, no matter how poor you are.
No, not for that purpose. No.
Okay, thank you. Representative
If I
Smith?
could just follow up.
Sure.
That was a decision of this body in terms of changing in the budget, changing the practice so that there were no public funds available for GAL, and that happened 15 years ago now. Well, no, not 15.
Yep.
Yeah, well, whatever.
Around 2008, around the budget crisis.
That's on our backs.
It can be fixed. That's a hypothetical. Thank you so much for coming and making your presentation. This is helpful.
Thank you for your time.
Could I just, Mr. Chairman, I have to call you Mr. Chairman because I could call you Judge, I could call you, I'm calling you Mr. Chairman. Knowing the work of this committee and knowing how difficult it is going to be, I think we were all pleased that you're here today in your capacity as being on the board at GAL. Is it possible that over the next month or so, you might consider coming in your capacity as a former judge or as the former chair of the Judiciary Committee to talk about what we might want to consider in terms of making the family court as good as it could be?
I'd be happy to come anytime you ask.
Thank you.
Interestingly, how my esteemed vice chair just basically read from what I was going to say. How about?
Mr. Chair, my eyes aren't good enough to read what you've written.
So you weren't copying off my paper.
Absolutely not.
I love it when a plan comes together. Now, we're going to be walking slowly through this because remember what we need from the folks in the audience is data that can be used by us in the way we're going to evaluate it. And that means specifics as a slice. And if you start to wander into talking too broadly, too generally about the case as a whole, I'm going to stop you. And not because you don't have something to say, but this isn't the forum. So with that in mind, first up, Dana Albrecht, would you come up? We have a pink card from you. It doesn't say time needed to speak. Do we have our buzzers and sirens? And I told them at 4 minutes and 30 seconds, we have a most pleasing and comforting tone. At 5 minutes, it's an outrageously gross buzzer. So
Is this on? Yes.
which is that? Oh, is that the comforting one or the obnoxious one? Okay, don't do the obnoxious one. We won't need it. Go ahead, sir.
Thank you. For the record, Dana Albrecht. I'm going to use my first 30 seconds here to play for you 30 seconds of audio from the May 1st, 2014 hearing in Sobel v. Sobel,
And where was it?
Nashua Family Court.
Thank you, sir.
Nashua Family.
Is this an authorized recording?
Yes. Obtained through.
Before the timer continues, the attorney, Representative Macbeth, your question,
Yeah, I do have a question. I just know that I believe that before the family court can be recorded, it needs to be approved by the judge. There has to be an order, and so I'm just making sure that we're listening to something that's lawfully recording.
could
Actually,
you attest to that?
they're public hearings.
public hearings?
Petition of Union Leader, 2002.
Okay, I can't rule on that, and I'm not going to. It's just, we will take your word, you may do this.
So Chairman, they are public hearings, but there are rules in place in the court regarding how they can be recorded. And I don't have a problem with listening to anything that's accurately, so.
I'm going to err on the side of let you do it, and if
And I
people
just lost
up
it
the
here.
line let us know to the contrary, we will make changes accordingly. My concern about liability is not us, it's about the people bringing things to us. And
Should know that Attorney Sternberg and I are very good friends. Very good friends. I don't know if he shared that with you or he did not. Friends? Yeah, we're very good friends. Very good friends, like the godparent of my child. We are very close.
So what you just heard was guardian ad litem Kathleen Sternberg and former Judge Julie Introcaso stating on the record in this hearing, May 1st, 2014, that they are very good friends. And I do assure the committee this was lawfully obtained through a request for the courts for recording. And I have no desire to play the whole hearing for you. That's the 30-second slice that's relevant.
thank you. And to your point now.
And to my point is that spawned 9 cases involving a conflict of interest in which Ms. Sternberg practiced and actively participated in court cases before Julian Tricasso. That's my first point. Also to the point here, on my computer, I have a 154-page PDF, which I am not going to read to the committee,
No, you're not.
but I'm going to cite chapter and verse. So this is, for background, this is the February 8th, 2021 deposition with exhibits taken of Ms. Introcaso as part of a misconduct investigation. So I would refer the committee to, I'd say page 61. This is one of those depositions where you've got 4 per page.
Chair's going to interrupt for a minute, and you're using names which I would prefer you now to refer back as the titles. And the reason for that is we're looking at process and not the individual. Granted, the individual did the process, but I would rather minimize the articulation of names. So you can say the guardian ad litem, the judge, the lawyer, the plaintiff's lawyer, the defendant's lawyer. You can use those terms if you would, please.
Okay. I would just like to read 61, line 21 of this deposition. I'm sorry, there are names here. The
If you
question
can
is
translate
from...
them into titles as
Yeah.
you're reading.
Got it. The question is from Philip Waystack, whose title is Counsel for the Judicial Conduct Committee.
And refer to him as such in the future.
Okay, so Counsel for the Judicial Conduct Committee asks former, or at that time current, Judge Julie Introcaso.
Judge.
Was there any discussion at all with you and Judge and marital master Bruce Dowpraw?
Marital master title.
Okay. Or you and the parties or the council that guardian ad litem Kathleen Sternenberg was on your conflicts list? And the answer from Judge Introcaso...
Hey,
Oh,
come on,
sorry.
pay attention to me.
Sorry.
Titles, not names. Thank you, continue.
The marital master has known that for 7 years.
Thank you.
So if we do the math on that, this is 2021,
Okay,
and that goes back to 2014.
got it.
So the marital master has also known about this conflict since 2014.
So the slice you're giving us is to the problem of
Conflicts.
conflicts, and the allegation regarding the conflict is that it would do what? Or
This
likely do what?
the allegations is this likely was very profitable for the guardian litem over the course of these 9 cases. The allegation is parties from some of these 9 cases may in the future provide different slices for you, so you might wish that background.
The allegation would be that the judge did not keep picking the guardian ad litem because the judge, in the judge's opinion, saw that guardian ad litem as an expert, as per Judge Gordon's testimony to us, but rather there was some financial benefit that would be gained by the guardian ad litem, irrespective of whether the guardian ad litem was qualified or not.
Exactly.
That's your assertion.
Exactly.
I mean, that was a leading question, I realize, but
Yeah,
you're the first
exactly.
one up here, so
Yeah.
you're the one that's helping us all here.
Okay. I'm not sure how we're doing on time.
We're doing all right.
Okay. So my second slice,
Okay,
again from this document, would be Exhibit 17 of this deposition.
again, titles only.
In Exhibit 17 is a order in my family law case dated October 16th, 2016, which is one of these appointments in which the marital master, knowing of this conflict since 2014, recommended the appointment of this guardian ad litem, which was then approved by the judge, who was close friends, as you heard the audio of this guardian ad litem.
So it's the second occasion of the same allegation.
Exactly.
Okay.
There are 9 occasions of this
Okay,
allegation.
and we've heard a representative 2 of them, and you've attested to 9, so we
Yeah.
can skip all of that.
Yeah.
Take it out of the micro in 30 seconds, please. Okay?
Okay. Net result is I was charged over $10,000 in fees for an investigation for relocation of my children to California, which is why they're now in Michigan. we can pick that up later with questions. And I would like to address one other.
I think that we're going to save the one other for another time, if we may. You've
I
given
can do
us-
it in 30 seconds.
I'm going to hold you to it.
Okay. Representative Gordon said was the point for judges decide issues of controversy. I would like to know, when there was no controversy, why sua sponte, my case has now been shipped to Michigan when I asked opposing counsel, the judge, to sign opposing counsel's proposed order, and he didn't do it.
Thank you for your testimony. And for the record, I specifically picked Mr. Albrecht to be first because he's a regular participant in our Children and Family Law Committee hearings. And I figured if I could yell at anybody, it would be somebody I know.
Oh, you're welcome to yell at me.
Well,
We could use a little more of that.
We're polishing a style here.
Yeah.
I thought you would be one who could handle that. Representative Long, question.
Thank you, Mr. Chairman. So can you tell me what brought that conversation to be of the judge and the GAL? They're very good friends. There had to be a preface to, I mean, I don't think a judge would say, oh, there's Mary, her and I are great friends. Was there something that led to that conversation between them?
That's actually the beginning of the transcript and the audio. You got a little thing before that. So they're essentially letting the counsel in the courtroom know that they're very good friends. So in that case, sort of people were informed, and in the rest of these 9 cases, not so much.
Okay, and
Follow
just
up, yeah.
follow up, if I may,
sure.
just for clarification, the judge you're referring to is no longer a judge?
That's correct.
Okay, thank you.
Any questions? Representative Macbeth.
Thank you. And thank you for taking my question. So just to follow up and give it context, the conversation that you played for us, thank you. Was that the judge and the GAL trying to inform counsel and ask if they reveal the conflict and then ask if they should continue or if they wanted them to recluse themselves?
There really wasn't much of a conversation after that. Presumably, if they did want a recusal, they would have had an opportunity to do so. I'm welcome to provide the whole transcript to the committee if you would like. The point of that was to sort of factually establish that there was a conflict.
I would accept the portion only that deals specifically with matters of recusal that apparently were not granted.
Exactly, yeah.
I would take that slice only, not the rest of the trial, please.
Yeah.
Okay. Any further questions? Representative Alexander.
Thank you, Mr. Chair. Is there any sort of requirement that there's a disclosure of a conflict or a relationship between the parties?
The Code of Judicial Conduct would require that. Unfortunately, that didn't happen in these 9 cases.
So if I could follow, it happened in
Follow up.
one of those cases?
Well, yeah, they were informed in that case.
Okay.
Yes.
Thank you.
The disclosure of potential conflict was disclosed in cases 2 and following? Did I hear?
No.
In any of them?
No, in fact, that's actually what led when it was sort of discovered. It came out in the Union Leader in October, and that sort of sparked a whole,
Okay.
you
So
know.
mandatory disclosure of potential conflict of interest was not stated by the parties who should disclose. Am I correct?
Yeah, that's correct. Over the course of these cases, neither the judge nor the marital master nor the guardian ad litem, also all 3 of these individuals had a responsibility in all of these cases to disclose.
That would be a separate file. I mean, a separate issue, I think. Okay, thank you. Thank you so much.
No further questions?
Mm,
Then thank you.
The chair recognizes Mr. Robert Tanguay, and you've kind of seen the form. I don't know you as well, so I'm not going to yell as loud at you. But that's kind of the form that helps us get what we need. And
Thank
we
you.
try to keep names to a minimum. You may introduce a name at the beginning and then refer by title because we're really looking for issues to fix rather than people.
Thank you.
You're welcome.
My name is Robert Tangway. I'm a father of 2 children, which I have not seen since December 1st, 2022, in which fictitious and false domestic violence allegations were made against me. There was no claim of any physical or sexual violence. There was no evidence presented at the hearing. It was conducted with judicial referee Joseph Maloney, and that will be the only time that I say that.
Thank you, sir.
She was a judicial referee. That hearing was on December 13th, 2022. She issued her final orders on December 14th. Well, she presented false findings of facts, physically and mathematically impossible findings of fact, to the judge who signed off on that. I wrote an emergency notice of false findings of fact, presented them to her where I spelled everything out and said that there was no findings of fact, basically just blew it off just to keep it simple. I proceeded with 3 more, and now we're at the Supreme Court right now, and which I believe it's Supreme Court Rule 21A is called a where they're not supposed to recuse, they're supposed to disqualify themselves if they know. They're supposed to go ahead and disqualify themselves. And what we have here in the state of New Hampshire is the New Hampshire Women's Bar Association, which is not associated with the Bar Association. Yet what they do is they gerrymander the lower courts, specifically the circuit courts, the family courts, and they say so on their website, in which one of our justices is a paid member of that lobby. And you're not supposed to have any effect or consideration on race, religion, and gender. So those orders were on December 14th, 2022. It has bled into with Judge Previtt in the family matter because she filed the domestic violence case against me to get strategic benefit in the family case when I filed a motion to have the court order mediation, which they have to in the family rules. So you're going to want to look at the rules. I'm not going to submit any paper evidence. But anyways, the judge in the parenting case brought judicial notice. That judicial notice was that I committed a crime, which the crime was, and he impeached me, and in writing, where he impeached me for the domestic violence, false, mathematically and physically impossible findings of fact by a judge. So he impeached me, and then he did this judicial notice, and then the judicial notice, I have obviously objected to it, requires as part of that rule, for one, I didn't commit a crime, I was never charged with a crime, and part of that rule is that I can ask a mandatory hearing on that judicial notice, which he denied. Then, at the end of April, he literally broke my First Amendment right to petition the court by sending back a filed affidavit and petition. Basically, the court system in New Hampshire, as attested in the last meeting where the justices were actually here, or the head justice, they're not following the rules. RSA 173B is unconstitutional. In the state of New Hampshire, right of accused, Article 15, no subject shall be held to answer for any crime or offense until the same is fully and plainly, substantially and formally described to him, or be compelled to accuse and furnish evidence against himself. Every subject shall have the right to produce all proofs and that may be favorable to himself, to meet witnesses against him face to face, and to be fully heard in his defense by himself and counsel. No subject shall be arrested And then at the tail end, every person held to answer in any crime or offense punishable by deprivation of liberty, your children, because that's what you can do when you accuse someone of domestic violence. They have the right to counsel at the expense of the state if need is shown.
Okay, we'll ask you to wrap it up, sir. You give me
Yes.
about 15, 20 seconds.
So I guess the point of my testimony at this point is to show that I want you guys to be very hard on the justices. There are laws, 633:4, interference with custody, out of state, with no justification. It's a Class B felony, and the police aren't prosecuting on the laws, and the justices aren't. It goes U.S. Constitution, state constitution, laws, court rules. That's the order that it goes. And the court has only discretion of the court rules, because if you look at
Okay,
Article,
we're going to wrap it up. sir.
yep, Article 38, Article 29, suspension of laws by legislator only. The power of suspending laws or the execution of them ought never be exercised but by the legislator. Thank you for your time.
Thank you, sir. Do you have anything written for us?
Not at this time, but I will be in contact, and I appreciate everybody's time and looking into this.
Well, sorry, the clock was about you speaking. I forgot about my colleagues up here, which,
Oh, perfect.
how could I do that? Representative Long.
Thank you, Mr. Chairman. Thank you, Mr. Tangway. So I'm just trying to get the complaint is due process. Is that correct? or would it
It's
be
actually what the first gentleman spoke about. Is
conflict?
conflict.
This was a conflict.
Not just conflict, but what we're looking at is what happened in this gentleman's case is it was in the papers. The judge actually whiteouted papers for the gal. She whited it out, and that's why she's no longer a judge. So the judge wrote false statements, mathematically and physically false statements, and just said, I don't have a lawyer. By the way, the plaintiff was represented with a lawyer, and I filed a claim, 633:4, interference with custody of Class B felony, with a 30-day written admission of it. And she didn't hear it. I didn't get a hearing. People aren't getting hearings in courts, in the
I'll write it
family
down as
courts.
due process. Thank you.
Okay, thank you. Any other questions, Mr. Tangway? Yes, Representative Katana.
Thank you, Mr. Chairman, and thank you for taking my question. You referenced, I believe it was RSA 173B, and stated you felt it was unconstitutional. Which part of that were you stating? I apologize.
So the reason, and thank you for asking that, the clarification on that is that there is, in order to be found, have a protection order in 173B to be granted, you must be accused, you must have committed a crime. So therefore, the process is not, as many judges wrote, the process, you're supposed to report a crime, the police are supposed to investigate and arrest. That's simple. And then you can add additional protection orders. But what they're doing is they're curtailing the system as a shortcut. And I believe this is specifically the Women's Bar Association, which if you go to their website, and I have that, says that they're working with women judges, officials. They're actually doing that. It's to curtail as a shortcut to any type of due process, which is constitutionally protected, and to do so on offers of proof, which is against court rules. You cannot get a restraining order shall not be issued on court rule, on offers of proof. So they're basically just the lawyers just testifying, lying, and saying whatever she has to say so that they can get protective orders. And then what they're doing is they're taking away your right, your liberty to be with your children. They issue children, they issue property, they can issue payments of money. It's unconstitutional in any way. And the only way that it could be considered constitutional is with the domestic courtroom protocol, which I also have that, and that was not followed in this case, and is not followed in many cases. Thank you.
Seeing no further questions, thank you, sir.
Thank you so much.
Chair recognizes Dale Savoy. and we're all figuring it out as we go along. But you know what we're trying to do.
Yeah.
Yep,
So
thanks.
the reason why I'm here today is I guess to put it into specifics, there's probably a lot of things, and I'll probably have to come back multiple meetings. But the big one is the inherent bias of the court system to give custody of the children to the mother, when it currently appears through U.S. national statistics that actually is probably the worst case scenario for children. Giving children over to a single mother home has increased suicide rates, increased dropout rates from school. Just about every single statistic that we're looking to avoid in public increases when you give children to a single mother home. I'm experiencing this personally through my own divorce situation. But when I read this and you look into it and you try and get the stats to confirm that through the state of New Hampshire, they don't keep any stats on this stuff at all. They keep no stats on the outcomes of children. I can tell you, when I go into the courtroom, the judge certainly doesn't ask, how are your kids doing? I've as many times, I've been into the courtroom probably a half a dozen times over 7.5 years, still ongoing, and not once did a judge ever ask how the kids are doing. This last go around, I had to convey to her that all my kids at this point are adults, and there's still a contention going on with child support, that they're basically floundering. Their mother is encouraging them to stay at home with her. All the adult children, mind you. My kids are not engaging in their future, if you will. At least not to the extent you expect for the age that they're at. And that, in general, would be less likely to happen if there was a father involved, which I was not allowed to be other than through visitation. You literally become basically just a guest in your children's lives. That's the best you can expect. You can't offer anything of any kind of substantive parent advice or anything like that, because you're basically just a guest in their life. You don't get equal time with the kids by default, even if there is no situation where there is. I mean, it was presented when, like in my example of my case, where my kid's mother basically went into the courtroom and said, "I'm afraid." That was it. That's all it took. And that's what the judge put in the decree. I had a communication with my oldest daughter, who at the time was an adult, that she needed to get her shit together. My ex used that line as a form of abuse. And part of the decree why they took my kids away. It's absolutely ridiculous. And the national statistics on it are horrible. Absolutely horrible. You look at just the incarceration rates of single mother homes. It's a nightmare. Yet we continue to assume that the best place for children is with their mother. And we don't keep stats on that. We just assume it. I've actually requested information on that. And you go through the court system and they literally tell you, we don't keep those stats. We just assume that the best place is for the mother. And it's awful. And the outcomes, the overall outcomes, is disastrous for us as a civilization.
Mr. Savoy, you're now starting to repeat it, and
Yes.
would you take some questions from us?
Absolutely.
Number one from me, you made an assertion that the national statistics say.
Yep.
Could you present documentation to this committee?
Oh, I would love to, but what happens is they keep you can get those stats basically through news reports coming out of there are institutions that they will allow this information. You have to basically be a research institution to get this information,
Well,
and they
if
will
you-
allow that to now be disseminated to these news reporters or whatever after they've put it together.
Okay, since you know about it,
Yep.
I'm sure you read it.
Yes.
And in that case, I'd like a copy of it.
Okay.
Second thing is...
It's actually quite easy. You can go right onto Google and
Yeah,
just
but
do
I'm
a
not
search.
going to because I'm underpaid and overbusy. So would you do it, please? Because you're trying to convince us. Could I
yeah.
ask my research staffer, I believe that there are states where it has been stated, and I grant that's a broad term, where co-parenting is the expectation unless solid reasons otherwise. I would like to know that, tell me some states. Also, what is that determinant presently in New Hampshire? What's considered best practices in New Hampshire? And once again, I would just suggest to you that the reason there were no statistics available in New Hampshire is there's almost no statistics available in New Hampshire for almost anything, because we have statistic phobia in this state, and I can't run my deaf and hard of hearing committee as well as I'd like
I
to,
know.
because nobody will.
How
do
can you
stats.
possibly do your job effectively if you don't have this kind of data?
Thank you. You're making my point. Any other
It's-
question? Any questions from anybody up here? Representative Long.
Thank you, Mr. Chairman. So you mentioned both your kids were taken away and you have visitation. So which one is
I have 4 kids. One was already an adult, so there was 3 kids that basically, I don't want to say taken away, because I still had limited visitation, not because of there was any finding of abuse or anything like that, although that is what she tried to claim, and she certainly got me kicked out of the house. I had to live out of my car for a while, just so that she could get me out of the house, which is the game they play. They basically that's how they work. They set it up so that you kick the father out of the home, right? Now you have custody of the children inherently. You go through the whole separation process, which is just awful. And supposedly, like in my case, it was I forget what they call it, but it's a non-contentious divorce kind of deal. And so they go in supposedly the easier path if they do that. You go in and they still, instead of it being non-contentious, my ex basically brought forward everything under the sun as if I was doing some kind of abuse link. Then there was never any finding in that. Eventually, the judge did give me what she said was equal custody, which is not equal custody. I got better than every other weekend, which is what most dads get, apparently. I got better than that. I actually was able to see my kids every weekend, but in the overall time of your kids that are there in terms of their free time when they're not in school or whatever it's not equal. It's not like I got equal time. I got to see him on the weekends, and then the whole rest of the time it was mom had him.
Are you saying that all kinds of accusations were made against you by
Yeah.
your ex that were not investigated as to fact?
Well, they were only basically presented as hearsay, so there was really no. There was for the reason the judge didn't feel that there was a need to go do an investigation. There was like no implementation of a guardian ad litem or anything like that. It was just what they do is that all it takes is the mother to say anything negative about the father. They grant them the ability to kick the father out of the home under the best interest of the children, right? Everything is claimed under the best interest of the children. It ultimately comes down to, they'll even tell you, and it's even in the circuit court rules, that ultimately none of this matters other than the best interest of the children. And that's exactly what the judge uses in order for their outcomes. They'll state, in the best interest of the children, X, Y, Z. And that's how it works.
Will we take another question here? Representative Lanza.
So what I would like to ask you, thank you for taking my question, is when was this heard? When was your case heard? Where was it heard?
So my case, is Hillsborough County in Goffstown, the Family Court Division.
When?
So it's been ongoing. It's still ongoing, and it's been going on for 7.5 years. So
Would like to know the date when the allegations were made against you.
I can get that to you. I don't know off the
That
top of
would
my
be
head.
helpful
Absolutely,
for
yeah.
our file, so we can go back and look
Yeah,
at
yeah, yeah.
it. It's
Yep.
not that we don't doubt you, but trust it. But
Oh no,
verify.
absolutely. I can even get you. I'll get you the court docket number.
That'd be nice.
Right, and you just look at the divorce decree, and the judge outlines the reason for how she broke down, who got the custody of children, all that stuff. You just read the decree, and it's right
Thank you
there.
so much. I apologize, Representative Lanza. I jumped in the middle of your question. Do you have anything further?
No, thank you. I think I got all my information right now, especially when he sends any information back to us. Thank you.
Absolutely.
Thank you, Representative. Anyone else? Representative Ball.
Thank you, Chairman Pearson. Were you offered, and thank you for coming and taking my question, were you offered any free guidance or assistance through the courthouse when you entered the courthouse?
Yeah, that's a great question. So, in order to get free assistance or something like that, you got to meet a certain threshold. You have to be under a certain threshold of income, kind of thing. I did not fall into that, mainly because I have a good income. I have a high valued house, and it's nearly paid off, and I also have a good retirement account. What I didn't have was direct access to available cash. My mistake. I didn't know at the time that I should be saving up money for a divorce, because I was blindsided by that. So
Did you follow up?
Sorry. Thank you. Just to clarify, so there was no one in the courthouse to help you fill out paperwork or how to address what was being brought before you?
What was brought before me, for the most part, I understood. So, I was able to fill it out for most of it. In terms of like an attorney or something like that, the judge tells you right up front, you really should get an attorney. And typically that's going to cost you $12,000 up front. That's what the judge told us. And that's just to get the ball started with the attorney, right? I didn't have $12,000 on hand, so that wasn't happening. And only that, in talking to my peers, going around, and I talked to many of them, my coworkers, my peers, and all that kind of stuff, and the ones that did get their attorneys, if you will, they said that they liked the fact that the attorneys kept them giving a certain amount of money to their exes, but almost all that money they would have given to their ex, they wound up giving to their attorney anyways. And that happened 100% of the time across the board. So I came away, there wasn't really a lot of benefit to having an attorney. And it became clear to me that by default, mom gets the kids anyways. And I didn't really have a claim, and I was, as a practicing Christian myself, I wasn't going to be making claims against her, falsehoods against my ex, in order to try and somehow get custody. And I'm glad I did not do that, because the whole goal between the attorneys is basically throw as much stuff against the wall, and hopefully some of it sticks. And when you're on the receiving end of that, let me tell you, that sucks a lot. And that's exactly what they do. My ex's attorney, she just threw as much stuff up there, true or not, against the wall. And her being the plaintiff, she goes first, the attorney for my ex. She went first. She gets to throw all this stuff up against the wall, and you got to sit there and try and go through and defend each one of them. And if you don't defend against them effectively, you're guilty of that. In fact, you're guilty as you get in there, and you basically have to prove your innocence.
Thank you, sir.
I'm hearing your ex-wife had counsel, and you went pro se.
Correct.
Which is an inherent disadvantage, and you're too rich to get something for free, but you're too poor to be able to afford something.
That's right. I fell into that window where it's
there is something worth looking at.
Yeah.
Okay, any other questions? And seeing none, and I think we got about enough pink cards for the time remaining, so thank you, sir.
Thank you.
And next is Randall Collier. And I think you've seen how we roll here, and
I can roll.
Thanks.
Thank you, Chair, Special Committee. My name is Randall Collier. I like everything that's been said here. There's been a lot of fallacy. There's been a lot of misconceptions. There's been a lot of good questions. So right now I have a $48 million suit in a Supreme Court through Belknap County Court. Deprivation of rights, 24 violations of due process. I know I spoke in front of this committee before.
Yep.
So there's a lot of things that I brought to the Supreme Court's attention, and a lot of people are obviously suffering at the hands of these family courts. First of all, when you go into family court and they give you a paper, say for criminal threatening or domestic violence, once again, allegations were unfounded. The court says that they gain jurisdiction over the parties and this is on the 12413 order. It's been going on for 12 years. The court says they found evidence by this order that it has jurisdiction over the parties and subject matter, and the defendant, upon service, will be given reasonable notice and opportunity to be heard. I hereby certify that I have read and recommendations and agreed to the extent the marital master, judicial referee, hearing officer has made factual findings and applied the correct legal standards and facts determined by the marital master, judicial referee, signed by the Belknap County judge. However, that's actually a illegal, unconstitutional way to gain jurisdiction over the parties. Legally, you need three elements: subject matter, person am, and territorial. So I guess a long time ago, family courts were moved from Superior Court, and now they're part of the equity court and not a criminal court. So these family court judges like to remove our constitutional rights to our children without actually a criminal hearing, and then they deny access to evidence to defend against the judge's findings. I want to bring special attention to you guys, since you guys have this committee up.
Okay, we're going to need a specific, because so far I've heard a very broad generalization that I've heard about 1,100 times since I got to the legislature 7 years ago. What I want is a specific example from you.
Well, the specific examples is equity court judges can't have subject matter jurisdiction over people.
Okay.
Because equity court is finances and property only, and the only way in a constitutional republic as an American is through a criminal court and a jury of your peers and be able to access evidence to defend, which we're
All right,
all.
well, I'm going to back you up because I don't write as fast as you talk. Equity court. Your allegation is that family court or family division of circuit court should not be hearing these cases.
Correct. They have
This
no
is an
legal
equity
ability.
Court.
Right.
So family court, and will you provide us with paperwork that backs up what you believe?
32 pages right here.
Okay, well, that's why I have two clerks. Okay. Sorry, continue.
So they say they gain jurisdiction over the parties, but they legally don't. Secondarily, person am jurisdiction has to be met in order to take your rights away, and that's actually being wanted for a crime, which means there's evidence of corpus delicti and 3 elements of an actual crime against somebody to have your parents removed or have your parental rights removed from your kids. So this has been going on for 12 years. I've seen my son 4 times in 10 years for a total of 6 hours. So the other
So
part.
your allegation is not primarily, I mean, it's downstream what they did. Your chief allegation is they had no business to do this in the first place, irrespective of what their decision was. It was the wrong venue constitutionally.
Not only was it the wrong venue, but then they violated all the state statutes and federal law in hearing the case.
So it's, I love this phrase, fruit of a poison tree. Go on.
Yeah. So I know Representative Long, we spoke last time, and I think it was regarding the Troxville versus Granville case, the parental alienation. I think it was you. However, since then, New Hampshire Supreme Court has also ruled in the Miller versus Todd case that false allegations is enough to overturn custody, and family court should have never granted primary custody to the mother on the false allegations. However, New Jersey Supreme Court just ruled 2 years ago, and I want you guys all to listen to this here. Where'd it go? Okay, let's give it to the North Carolina Supreme Court. In 2000.
Got to wrap it up.
Okay, North Carolina Supreme Court granted the father $300 an hour for every hour that the family court took him away from his daughter. He was granted $3.1 million, and the daughter was granted $1.5. New Jersey Supreme Court 2 years ago just put out an order, and it said, come on, where'd it go? Sorry, guys. I just had it. Well, the New Jersey Supreme Court said September 27, 2021, they clearly explain how these family courts cannot lawfully shift the burden of proof to a parent to prove they did not commit the offense, such as abuse in this case. to justify infringing on the rights of parental rights over their child. So there's been multiple Supreme Court cases that have ruled that family courts don't have the ability to take or give parental rights. That's only through actual criminal process. So not only is all these family courts trying to gain jurisdiction over the parties illegally, they violate state statutes where they also say on
Okay. Chair now recognizes Donald Gilbert. I almost said Gilbert, but I've been watching too many hockey games lately. Is it Gilbert or Gilbert? Okay. Yes, sir.
Thank you.
All right, you got to hit it again. I'll keep my hands off the button here. Thank you.
Thank you, Chairman Pearson and committee. I first want to follow up with some of what was already testified here today. First off, with what Representative Ball recently just asked, is if there was parties within the court system that could provide assistance with filing. What I have recognized over the last 13 years of being in the family court division is that the clerks, at least in the 6th District and also down in Cheshire County, are very apprehensive of assisting filers with processing things, stating that it's a conflict of interest for them to assist with that. So I do feel that that's something that should be addressed, that clerks should be obviously not particularly stating out what needs to be filed, but I do need to state that, you know, they should be assisting people that are less fortunate with understanding or having disabilities, have that accessibility to file. Moving forward, I would like to follow up with Ned Gordon. And with regards to the guardian ad litems, in my 13 years in the family court, I'm obviously a young gentleman. My children, I was birthed when I was 17 years old. That being said, we have had I've had probably 15 different guardian ad litems over the 13 years. Some that were voluntarily recused, some that were forcefully recused. I do feel that the family courts do go ahead and overextend the processing of providing a guardian ad litem when they could be particularly piecing these pieces together just from the testimony from the parties. And they are utilizing these guardian ad litems more as an investigative and parental guidance rather than, you know, actually conducting best interest determinations. Following up with the division, and this is my main point here that I wish to speak, and I do wish to come back and speak further when I have a proper set of guidelines forth so I can lay those grounds. But following up with DCYF and Mr. Ribsam, primarily what my testimony will be here today and in future sessions is I do believe, and I believe that you're going to find out from many constituents as well as from the judges themselves, that this family court division issue is primarily due to DCYF non-compliance with their own policies as well as with RSA 169C and 170G8AB.
What's the last reference?
170G8A and
170G.
A, which is the records of the division and the court. To follow up with that, on that notion alone, and I'm sure Judge Gordon can follow up with this further, is with CASA. There is a very lack of oversight on CASA themselves. There is a lack of admin rulings, and there is a lack of statutes for CASA. They're point blankly in the GAL and under the 169C guidelines is portions that state that CASA's records are subject to 170 G8A. But if you go through 170 G8A, nothing regarding CASA is mentioned. So there is some statutes that are missing definitions and guidance. And what I've seen is a lot of attorneys and DCYF themselves do not understand what 170 G8A even entitles or entails. Personally, with my experience in my matter is ongoing, I'm more than welcome to give the case number. But we've been ordered for over a year now for DCYF to turn over all documents, all third-party documents, including restricted access documents. With that, DCYF is refusing. To follow up into my next point, which I will continue at a later time, will be that I am currently being violated on my Fifth Amendment right. DCYF has requested that I participate in post-conviction therapy. And post-conviction therapy is not afforded to me because I'm not even charged with a criminal crime. My case has been going on for 3.5 years under the 169C. And
Okay, good. Thank you. We'll look forward to you coming back, and if you have anything for us, you can hand it in, send it to the clerk, what have you. Any questions for Mr. Gilbert? Yes, Representative McMahon.
Thank you, Mr. Chairman. Mr. Gilbert, just to be specific, the directives that you provided here are specific to DCYF and not the family court. Is that correct?
no, they are family court RSAs for abuse and neglect cases within the family court.
All right, to be clear, you said that there was non-compliance by the DCYF, not stating there was non-compliance or appropriate following of rules. That's why we're here with the family court. Can you clarify then what's going down here with your case?
Sure thing. So obviously, as I'm sure everybody is aware, DCYF provides the proposed orders for the judge, and the judge kind of just rubber stamps those orders in a sense. Obviously, we've had a lot of, I have a 3-page article from our judge that contradicts what DCYF has claimed. But that being aside, so basically with that, DCYF is proposing these orders that are unconstitutional, that do not even comply with their own policies, do not comply with 169C. The judges are then, unbeknownst to them, a judge is, I don't foresee is to know that, post-conviction therapy is, what it is in a sense, under what DCYF is proposing. And obviously it would be a violation of the Fifth Amendment to require somebody to go ahead and provide post-conviction therapy when you're not convicted.
Okay. Thank you very much for that clarification.
Anyone else? Representative Alexander.
Thank you, Mr. Chair. I'm just trying to get a little more detail on you being forced to participate in post-conviction therapy. Was that a court order?
That is part of the dispositional orders for the court, correct?
And if I could follow up, Mr.
Follow up.
Chair, has there, in your experience, has this been like a tradition of the court to do this? Or I guess I'm wondering why you were appointed, what the reason was for you to be appointed to this.
Sure thing. So obviously the baseline is a 169C, which is abuse and neglect case. We won't go into the specifics today, barring the requirements under 170 G8A. That being said, so with this, in my research, in my follow-up with the Office of the Child Advocate, who I hope will testify before this committee at some point, and I would welcome them to commit to testifying, that this is the first case that New Hampshire has seen that there is a 169C for this type of matter that does not have a criminal aspect to it. So with that, we'll go along with my further testimony later on, but the division is prolonging these cases. Again, this is 3.5 years. The statutory limit for this type of case is 12 months. we're going on 3.5 years. They're awaiting criminal aspect that is never going to be afforded, and the statute of limitations on criminal aspect is 40 years.
Representative Macbeth.
Thank you very much. Thank you. I just want to clarify. So the 169, you're saying DCYF, so they had a finding of abuse. Is that what you're saying? And then, but there was no criminal charges. And then you're saying the court, family court, included that finding and kind of found you guilty or of a crime needing the therapy. Is that kind of how that fell?
So it's by the preponderance of an evidence, which is belief that something could possibly happen. It is not a conviction. It is not a finding of guilty. It is a belief that by whatever evidence might have been offered, there is a belief under a hint of a fraction of whatever that may pertain. By the guidelines of the court, it's 51% belief that something possibly could happen.
Are you asserting that what they're making you do should have only come out of a higher standard of evidence than they used?
Correct. It's post-conviction therapy.
Thank you.
So.
Thank you so much, Mr. Gilbert.
Thank you.
And we'll see you soon. And the last card we're going to use, and thank you for somebody who put in a pink card saying, I want to be first next time, like that, is Attorney Paula, is it Verm? Help. I want to get it right.
No judge in my entire legal career attempted to say my name when they first met me. They said attorney, and they let me say it.
I'm not a judge, although people want me to go to law school.
Yeah.
I thought they were my friends, but go ahead.
It's Worma. Put the two
Worma.
dots over the last D.
It's an umlaut. Got it.
Okay.
Start the clock.
Today I'm talking about general stuff, and I'm actually surprised that Ribson and former Judge Gordon, which is what I call him because I was an attorney, were here testifying because about the GAL and the DCYF piece of it, because part of my written testimony, and I only have about 6 pages of testimony, the rest of it are exhibits that support it, facts that you want, was that Ribson ignored a right to know, and Judge King ignored it. It's a little different under the judicial. It's a right to know under Article 8. It's not under 91A. Just didn't reply. So anyway, with that, one thing and this is off the top of my head because of some testimony from Judge Gordon, CASA obviously has guardians ad litem in the court. They also have a seat at the guardian ad litem board. So being part of the body that regulates yourself pretty much guarantees that there aren't going to be any discipline problems against you. With that, I don't know if I'll get through the rest of my 5 minutes, but I do have it written. First of all, I'm submitting this lengthy written testimony at the end. I'm actually surprised. I wrote down that few lay people can explain in 5 minutes a laundry list of how they were wronged, and they're doing pretty good. Some are knowledgeable, some are not. Another thing, the judges. Okay, when you picked up, and this is also in my written testimony, when you moved family matters out of Superior Court, particularly divorce, you moved it from a constitutionally created court to a statutorily created court. And part of what I'm submitting you is the Supreme Court case that says judges' broad judicial equity power ends at the courtroom door in a statutorily created court. So all the judges, and probably Judge Gordon as well, were making some broad equitable orders, such as appointing a commissioner to sell a marital home, which they didn't statutorily have the power to do that. They used to It was a very old common law right of judges, and it could have happened in Superior Court. You know, they order up parenting coordinators. They all kinds of things that they're making orders on that are flat out illegal. And I don't have all the proof in this because otherwise you would have had a stack that high. And I had 1 week to prepare this. So you're going to get it a little at a time.
Just the Cliff Notes.
Right. And the last thing I have in, okay, also evidence that Gordon MacDonald ordered a sign on every courtroom door in the state about this no recording without the permission of the judge. And I'm not about to ask any judge to exercise a constitutional right, so I don't do that. He doesn't like me very much because I sent him an email about that ridiculous order. The other thing is statutorily, the GAL is allowed to recommend a therapist who the judge will then pick. There's going to be later testimony on why it is such a bad idea for judges to pick their own witnesses in cases. And it is a problem. And it really violates people's rights. You know, I think you've already heard there's a pretty short list of GALs. There's a shorter list of psychologists that are willing to do these evaluations, and the judges are
30
also
seconds.
picking them. So anyway, you know, they do things all the time, like order mediation in the presence of domestic violence. I found the practice was widespread. So I have more. It'll be in writing, and I'll turn it in.
Thank you so much. Any questions for the counselor? Anybody? I would especially like to have more, and I know I don't have to beg you for this, on your assertion about moving when the family court moved from a constitutionally created court to a statutory court that does not have the right to mandate things beyond the court door. I'd like to explore that. So if you can give us proofs of
New
that.
Hampshire Supreme Court opinion is in here.
Thank you. Any other questions?
May I make one more point?
Nope.
Okay.
Thank you. And we have come to the end of today's hearing. Unless anybody on the committee has anything you'd like to input, I think we've got a number of different kinds of things we might profitably explore. There'll be more evidence, and we're siloing, maybe I shouldn't use that word, but we are vertically putting them into folders, like those folders, so that when somebody comes with something that goes to that point, that evidence goes in there. So one of these days, when it's time to analyze, we'll look at them folder at a time.
Mr. Chair.
Representative Alexander.
Thank you, and I apologize because I did miss this organization meeting. Is your intention to do some like listening and then like a day of like talking about it amongst ourselves?
I want to do enough listening that we get a good sampling under each one of the topics from different people.
Preferably
And then
more
maybe
like
over the
listening than
summer,
talking.
there'll be some homework assignments of some brave volunteers will read the transcripts of the court hearings that have been given to us, just a slice. Why do we want to do that? Do we disbelieve what people say? It's not a matter of that. We just want to make sure from our perspective that if anybody asks, we've seen in the court transcript what the person said was there. I think everybody wants that. Then I suspect, and I'll be talking a lot with my vice chair, but there'll be some days when we will go through the different folders of topics and see what happens, but we're kind of feeling our way along. Madam Vice Chair?
Yes, thank you. This is all one packet. Mr. Chair, would you consider it appropriate to ask OLS, perhaps Mr. Lambert or someone else, to give us a brief explanation of the issue involving the difference between a constitutional and a constitutionally established court and a statutorily established court, particularly in terms of equity authority.
We are blessed by having Christina Dyer and Richard Lambert.
Oh, okay.
And there's so much work here that I don't think they're going to fight over who gets what. So we'll talk about, is this one you'd like, or would you like this to go next door? And because either one of you will do a great job. So one of the two of them, I'm sure, will tell us. Any other homework for the research staff? Yes, Representative Macbeth.
Thank you so much. I have a question. Some of the material that's been handed in, how do we get copies of that? Is that going to be scanned and sent or print to us, or do we need to contact the?
We are working that out with Aaron Goulet from the Speaker's Office, Jim Cianci, House Legal Counsel, and the IT crew. In terms of what may we, and if we may, how should we, and that sort of thing. I think the Chief of Staff to the Speaker, Aaron Goulet, has spoken with the clerks, or at least one of the clerks, both of the clerks. And so this is a bit of a work in progress. We already have a number of documents that I've turned in that will be available, such as the 2 reports from the 2012 redress of grievances. That's in there. We got all kinds of cool stuff coming. And our clerk experts here will let us know how we can do that. For those of us who aren't Luddites but have great respect for their movement, there may be some of it in paper. We are finished. Sorry.
I got nervous there.
Sorry.